Professor Chairman, let me also float on the established protocol, and just to save time, no disrespect to the distinguished invited guest here. The Chairman, taking a look at the topic for discussion today, which is the 1992 Constitution of Ghana, the perspective of a legislator. It is almost the same theme that I spoke to at the Great Hall of KNUST on the 12th of July 2022. I guess the Chairman considers my presentation there that it was a domestic conversation with local constituents in Ashanti, or my alma mater, KNUST, or perhaps it was for the northern sector. I believe it's the reason why the IEA has invited me to share my thoughts with compatriots in the southern sector. It's about the same thing that I did at KNUST. But it's good for me in the sense that I didn't have to begin afresh. I've just had to do a brushing up and a few adjustments in phraseologies and syntaxes. Otherwise, generally a restatement or a re-emphasis of my KNUST submission. As a Member of Parliament, I have since 2017 flagged the need to revisit the 1992 Constitution. The 2022 Annual Action Plan of the Ministry of Parliamentary Affairs encapsulates this activity as the Minister's priority area under the key issue, deepening democratic governance. This is because, as a practicing parliamentarian of continuous 25 years experience, I believe I have some sufficient acquaintance with the 1992 Constitution, and therefore I'm properly primed to advocate for a review. I'm accused by my colleague, the minority leader, that the Constitution is my second Bible. And he says to me the other day that even in my dreams, he sees me carrying the Constitution. I didn't know that who is that man? Prophet, is it Obini? I didn't know that he has transformed himself into a prophet. Professor Chairman, distinguished guests, it has been 3 decades since the 4th Republican Constitution of Ghana was promulgated on the 28th of April, 1992. This Constitution has endured and served the nation generally well, having successfully underpinned the 4th Republic, which is the longest democratic dispensation this country has enjoyed since independence. However, there have been numerous appeals for the Constitution to be revisited. Many well-meaning and prominent Ghanaians have made suggestions for amendment of the particular constitutional provisions and even a reconsideration of the suitability of our system of governance, which framework of government, that is presidential, Westminster, or a hybrid, would facilitate optimum development for a small unitary country such as Ghana. 3 of our past presidents, President Rawlings, President J. Kufuor, and President J.E.A. Mills, have all at various times spoken about the need to amend aspects of the 1992 Republican Constitution. The current president, Nana Addo Dankwa Akufo-Addo, has also joined the fray of those who have been unambiguous and unequivocal in their advocacy for amendments to the Constitution. They cannot all be wrong. However, just like any other endeavor in life, there are some of our compatriots who are opposed to the idea of a review. Some notable Ghanaians, though in my considered opinion, in the minority, have expressed the desire to maintain the status quo. As far as they are concerned, if it is not broken, you don't fix it. There are just others who opine that the spirit of the law must guide the conduct of the polity. Ghanaians, rather, they argue, need an overhaul of their values. In other words, something more than a constitutional review, a complete transformation of the Ghanaian is required. Something more than a constitutional review is required. It's the reason why it has been said in certain quarters that the Constitution has not failed, but rather as a people we have failed. My thoughts are simply that the preamble of the Constitution establishes the mission of the Republic. And I'm quoting, the preamble provides, "In the name of the Almighty God, we the people of Ghana have established a framework of government to secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity. This we have done on the platform of freedom, justice, probity, and accountability, and based on the principle of universal adult suffrage, the rule of law, the protection and preservation of fundamental human rights and freedoms, unity and stability of our nation. Now, the sovereignty of Ghanaian people and the supremacy of the 1992 Republican Constitution are established by Article 1, Clauses 1 and 2. Article 3, Clause 4 commits the defense of the 1992 Constitution into the hands, quote, of all citizens of Ghana, and unless and until all citizens of Ghana elect to abandon that responsibility, the right and duty at all times to defend this 1992 Constitution, the 1992 Constitution shall continue to exist and be operational. Professor Chairman, Articles 1 to 3 constitute Chapter 1 of the 1992 Constitution. Chapter 2 is on the territories or the areas that make up the geographical entity called Ghana. Chapter 3 defines who a Ghanaian is, whereas Chapter 4 covers what the laws of Ghana are. Chapter 5, which comprises clauses 12 to 33, is on the fundamental human rights and freedoms and the protection of same rights and freedoms. Chapter 6 provides the mission statement of the state, captured as the directive principles of state policy. It is the policy encapsulation of all the overall development plan for the country, expressed as political objectives, that's Article 35, economic objectives, Article 36, social objectives, Article 37, educational objectives, Article 38, cultural objectives, Article 39, international relations objectives, Article 40, and duties of citizens, Article 41. Now, the coalescence of these objectives should be the realization of basic human rights, a healthy economy, the right to work, the right to good health care, the right to education, as Article 34(2). In the event an obligation is imposed by the Constitution on Parliament, the President, the Judiciary, the Council of State, Cabinet, political parties, as well as other relevant bodies, to be guided by the directive principles of state policy in taking and implementing any policy decisions which would culminate in the establishment of a just, united, free, stable, and prosperous Ghanaian nation, underpinned by the transparent and accountable government referred to in Article 34(1) and indeed the preamble of the Constitution. Chapter 6 provides the mission statement of the state, captured as the directive principle of state policy. It is the policy encapsulation, as I've already said. Democracy is a representative government, and in recognition of that, citizens are accorded the right to vote, which is secured via registration for the purposes of public elections and referenda. That is provided under Article 42. It is therefore strange, Professor Chairman, for people to rise up and canvass the idea that every citizen of 18 years must be allowed to vote. Article 43 grants the right to Ghanaian citizens who are 18 years of age or above and are of sound mind to vote. But that right can only be exercised after one has registered as a voter. So if you are 40 years of age and you are Ghanaian and of sound mind, you cannot walk to a polling station to cast your vote unless you have your name in the book of life. That is the voters' register. Professor Chairman, political parties are the vehicles for shaping the political will of the people to disseminate information that is well researched and appropriate, not propaganda, on political ideas, social and economic programs, and sponsor candidates for elections to any public office other than the district or lower local government units. That is Article 55. And that is why political parties themselves must get it right and themselves be populated by experienced, competent, efficient, and effective persons who can churn out ideas which have the potential of maximizing the rate of socio-economic development to secure maximum welfare, freedom, and happiness of every Ghanaian, and to provide adequate means of livelihood and sustainable employment to the Ghanaian people and public assistance to the needy, as provided under Article 36 of the Constitution. Professor Chairman, the anchor of the 1992 Constitution is provided by the framework of government which sustainably secures for the citizens of today, tomorrow, and the day after tomorrow the blessings of liberty, equality, opportunity, and prosperity. Now, the principal strands of the anchor are: 1, the executive, the legislature, the judiciary, and the Council of State. Besides these, one can also identify other constitutional creatures, that is, independent governance institutions such as the Electoral Commission, the Media Commission, the Commission for Human Rights and Administrative Justice, the National Commission for Civic Education, the Public Services, comprising the Civil Service, Customs, Excise, the Preventive Service, Education Service, Judicial Service, Armed Forces, Police Service, Immigration Service, the National Fire Service, Audit Service, the Legal Service, the Parliamentary Service, Statistical Service, Health Service, Local Government Service, the Internal Revenue Service. We can also mention the government's statistician. Finally, one cannot be unmindful of the role defined for our chiefs under Chapter 22 of the Constitution. We have practiced the 1992 Constitution for close to 30 years now. Are the various strands firmly in place, effectively and efficiently functional, and contributing to the smooth functioning of the greater whole? Or is it the case that some of the strands are loosening up, or exfoliating, or even peeling off? Do some of the strands need tightening up, or repairing, or retrofitting? Now, I want to begin first with the perspective of a member of parliament on the executive. The president that the Constitution has erected in Article 57 is the head of state, head of government, and commander-in-chief of the armed forces. The executive authority vests in the president, Article 58, and the executive authority of Ghana extends to the execution and maintenance of the Constitution, all laws made under or continued in force by the 1992 Republican Constitution. Accordingly, all appointments into the public service are at the instance of the president, Article 195. The power to appoint persons to hold or to act in an office in the public services shall vest in the president, that is 195. Sequel to this provision, the president appoints the head of civil service, Article 1931. In the meantime, there is a conflict between Article 1947 and 71(1)(d) with respect to emoluments. The president appoints persons to the Police Council, Article 201(g) and (h), the IGP 202, Prison Service Council 2061 and (k), the Director General of Prisons 207, Armed Forces Council 211(d), the CDS and Service Chiefs, Article 212, Fire Service, SHRAG, Article 217, Commissioners of the NCC, Article 232, Media Commission 166, Government Association 1853, MMDCs 243. The governing boards of various bodies and authorities established by various acts of parliament, the appointment of ambassadors, high commissioners, etc. We are still counting. All public lands are vested in the president, Article 257. Every mineral in its natural state, in order or upon any land in Ghana, rivers, streams, water bodies throughout Ghana, the exclusive economic zone, and any area covered by the territorial sea continental shelf is the property of Ghana, is vested in the president, Article 257. This certainly is a monarch that the Constitution has created. The rest of us citizens hold him in awe, and if and when he strays, it is difficult to talk straight to the president. Kofi, am I lying? This arrangement needs to be revisited. It cannot be good for the growth of our democracy. The country needs a head of state and government. Therefore, at any given time, we shall have a president or a prime minister. There is an empirical study conducted by the World Bank which suggests that small unitary countries are better served with prime ministers as heads of state than president. The president has the whole country as his constituency, whereas a prime minister operates from his or her own small cell. When the parliamentary leader wins and his party wins majority of seats in parliament, he becomes a prime minister. His campaign purse is very lean as compared to the president's campaign wardrobe. Of late, the electioneering campaign funds of contestants at every level of political arrangement has been escalating. The campaign funds of parliamentary candidates from primaries to national elections is averaging $600,000. That is according to the research conducted by CDD in respect of events culminating in the 2020 elections. That is huge. We are yet to begin the counting of votes in the lead up to the 2024 elections. But the campaign pairs of a presidential candidate from party primaries to the national elections, by any proper reckoning and accounting, cannot be less than the equivalent of at least $50 million. Where do the candidates have such money from? There is a nexus between huge campaign expenditure and corruption through the award of contracts. As a nation, we must confront this. Do we need this expensive structure of government in the president, or a much lesser evil in the form of a prime minister who is as well much more accessible and accountable to the representatives of the people? We have a choice to make. In a strict presidential system, ministers are appointed from outside parliament. Invariably, they are all technical persons in the various fields who, when they come to be appointed, are able to assist the president in the determination of policy of the government. That is as required under Article 76(2) of the Constitution, and also for the efficient running of the state, as captured under Article 78(2). These are experts, they are technical people, they are professionals who add value to governance. In the Westminster system, the Prime Minister appoints ministers for the same purpose: the determination of the general policy of government and also for the efficient running of the state. The ministers in the Westminster system are not necessarily technocrats, but they are often long-serving members of parliament who must have served on committees for some time, risen to chair the committees, or perhaps served as shadow ministers and acquainted themselves with all matters pertaining to particular ministries, departments, and agencies, such that they might have become authorities in matters concerning the various MDAs. When such persons get appointed as ministers, there is manifest value addition, unlike what obtains in our Fourth Republic, where because of the hybrid system of government that's being operated, the president is compelled to appoint a majority of ministers from parliament. That is as required under Article 78(1). Ministers of state shall be appointed by the president with the prior approval of parliament from among members of parliament or persons qualified to be members as members of parliament, except that the majority of ministers of state shall be appointed from among members of parliament. You're all witnesses to what obtains in such agreement. Many ministers, deputy ministers, who get nominated and who appear before the appointment committee of parliament when asked fundamental questions relating to their designated ministries would respond. Mr. Chairman, I don't know, but please, you approve of me. When I get there, I shall learn. How are such persons, rudimental learners, going to assist the president in the determination of general policy of the ministries they superintend, or indeed of government? How are they going to help in the efficient running of the state? This is one principal reason why, as a nation, we are marking time. We are stuck because many of our ministers, approved by various presidents, do not add value to governance. I'm not here talking about the current MPP administration. I refer to all administrations since 1992. The time has come for us to mend and amend. Hasn't the time also come for us to place in the Constitution an upper ceiling of the number of ministers of state, and indeed of cabinet ministers? I've already stated, cabinet ministers assist the president in the evaluation of policies. All bills, agreements are presented to parliament, are underpinned by government policy and principles which cabinet ministers propose to cabinet. If you are not a cabinet minister, you are not part of this process of the evolution of policy. That means that a minister who is not a cabinet minister cannot assent or present a bill or agreement to parliament if that minister is not a cabinet minister and therefore is not part of the process of formulation of policy and principle. If that is the case, as I believe that is the case, why have such a huge number of ministers in the first place? The Constitution provides there shall be a cabinet which shall consist of the president, the vice president, and not less than 10 and not more than 19 ministers of state. Given the role of ministers of state, who cabinet ministers are, as for the running of the state efficiently and assisting the president in the determination of policy for his government. This is my contention, that apart from the regional ministers, the number of central government ministers may not have to exceed 19. And that means ministries shall also have not to exceed 19. All ministers, to be relevant and to be able to assist in the evolution of and determination of policy in their sectors, must be cabinet ministers. The excess numbers must be cut off and would significantly reduce public expenditure. For the avoidance of doubt, I believe the Constitution must provide for that. Because Parliament is not insisting on this, so the Constitution must provide for that. Now, Article 68 provides, among other things, whenever the President is absent from Ghana or is for any reason unable to perform the functions of his office, the Vice President shall perform the functions of the President until the President returns. That's Article 68. That construct means that whenever the President is absent from Ghana, it must be construed that he is unable to perform his functions as a President. Thus, the mere absence of the President from Ghana mean inability to perform the functions of his office. This cannot be true in this technological age, or in situations where the President exits the jurisdiction in his capacity as President to perform official duties for the country, for instance, at the United Nations, at ECOWAS, or at AU, or to engage other presidents in bilateral discussions in foreign countries. We need to amend this provision as well. Now, Article 78(1) provides for the President to appoint a Minister of State with the prior approval of Parliament. When a minister is nominated by the President for a specific ministry, he is vetted for that ministry. If for any reason the President has to move that person to another sector, Parliament must have the opportunity to vet that person again for that new position in order to satisfy themselves that the person has some competence and knowledge for that new designation. Otherwise, we may wake up one day to see that a minister has been appointed for horticulture, and the next day he's reshuffled to finance. Kofi, that is coming from you. I think it would be better for us to be able to assess the competence of any minister or deputy minister if that person is reshuffled in the court of Parliament via the appointment committee. Ministerial appointment is a serious business and should not be reduced to try and error, because government is about the lives of people. The Attorney General, who is a principal legal advisor to the government, is a Minister of State, appointed by an incumbent president. Article 88(1). The Attorney General is responsible for the initiation and conduct of all prosecutions of all criminal offenses. Article 88(3). All offenses prosecuted in the name of the Republic of Ghana shall be at the seal of the Attorney General or any person bearing the authority of the Attorney General. If the Attorney General is a minister in a ruling party's government, certainly human as he is, he will tend to treat his colleague ministers with kid gloves and only go after opposition elements and former ministers. It is proper and prudent to insulate the Attorney General and ensure his independence. For instance, the status of the Attorney General could be made equivalent to that of the Chief Justice, or at least a Justice of the Supreme Court. He must not be a Minister of State. By that, he will traverse several administrations and his financial autonomy will be guaranteed, and then shall we witness the demonstrable prowess and power of an Attorney General. An amendment, in my view, is required for Article 88. The National Development Planning Commission is a vital cog in the development agenda of this country. The broad architecture of national development is provided by the directive principles of state policy, expressed in the broad ambit of political objectives as related to political, educational, social, economic, and so on and so forth. The NDPC is mandated to craft a long-term development plan from these development themes for the nation, based upon which the various political parties are required to craft their manifestos. Article 55(3). When this has been achieved, then the relevance of Article 35(7), which provides that as far as practical, I'm quoting, a government shall continue and execute projects and programs commenced by the previous government, shall be established. This has become difficult to achieve because the political parties have no guide from the NDPC. On the part of the NDPC, it is not for want of trying. The truth of the matter is that the very composition of the NDPC, provided under Article 86, makes it politically tainted. It's populated by ministers of state at a given time. And regardless of the quality of its product or content, succeeding administrations, which comprise of different political parties, may abandon the product to begin their own enterprise. Professor Chairman, I believe this is one area that we have to look at again. And the Electoral Commission, this is a body that occupies a central role in the framework of government that we have established. Its commissions or omissions could either advance the cause of our democracy or draw us back. It is the responsibility of the Electoral Commission, and I'm quoting, to demarcate electoral boundaries for both national and local government elections, Article 45B. The Commission is charged with the function, I'm quoting, to review the divisions of Ghana into constituencies at intervals of not less than 7 years or within 12 months after the publication of the enumeration figures after the holding of a census of population of Ghana, whichever is earlier, and may as a result alter the constituencies, Article 47, Clause 5. It is the combined effect of Article 45B and 47(5), which drives the creation of additional constituencies by the Electoral Commission without any regard to Article 47(3), which provides, and I'm quoting, the boundaries of each constituency shall be such that the number of inhabitants in the constituency is as nearly as possible equal to the population quota. It cannot be that this becomes the resort of the Electoral Commission to be increasing the number of seats in Parliament anytime they come to review the division of Ghana into constituencies. This practice is not sustainable and does not exist anywhere in the world of the established democracies. At the inception of the 1992 Constitution, the constituencies in this country totaled 140. Then just about 5 months before the conduct of the 1992 elections, it saw an increase from, the number of constituencies saw an increase from 140 to 200. An overnight addition of 60 constituencies. A jump in the numbers by 60. That's an increase of 43%. Now, in 2004, the number of seats in Parliament was increased by 30, from 200 to 230. And in 2012, 8 years after the second exercise, the number increased by 45 to the current number of 275. It is now over 10 years. And the census has been conducted in 2021. It's been more than 12 months since that census was conducted. Is the EC to increase the number of seats or not? That's our dilemma. And to be honest, the people who stood to benefit from the last one now are having serious introspection. They think that the EC should not increase the numbers. But I think this is something that the Constitution must address. And I think I have held a view that we didn't need to have increased the number of seats from 200 to 230 and now 275. Going by the trend, perhaps one will say that it should go to 300 or 320. But is it fair to the state, the resources that we have, and so on and so forth? Again, the composition of the Electoral Commission excites a lot of agitation. On some occasions, the agitation is muted. On other occasions, the agitations are very loud, depending on which political party is in opposition, which party is in government. And of course, which party's president makes appointment of the members of the commission. Should it be subject to prior parliamentary approval? Should the commissioners be appointed to serve a defined tenure? Should the commissioners include party officers? I submit that the time has come to look at this as a matter of urgency. Elections have the potential of triggering strife in many African countries. We should not allow any negative incident to happen before we rush to firefight. Now, the legislature, parliament, the core functions of any parliament are representation of constituents, 2, deliberation on matters that come before the House, information, dissemination, legislation, power of the purse function, oversight, ratification of treaties, conventions, protocols, agreements, including loans, etc. All these are not provided in our Constitution. These functions, representation, the function of deliberation on matters even the power of pairs function. How many of us have looked at the Constitution to realize that the job that we do, and we are soon going to apply ourselves to it, that is scrutinizing government budget and approving of them. The Constitution, the 1992 Republican Constitution, does not assign that responsibility to Parliament. It only talks about a mid-year review and supplementary estimate, that we should approve supplementary estimate. The main budget, we're not giving that function. Surprisingly, I believe that was really an oversight from those of them who crafted the Constitution at the time. I'm talking to you. So we should be looking at this. The second matter that should also concern us is the mode of choosing members of parliamentary candidates by the various political parties. And I think the political parties must do serious introspection and look critically. In the established democracies, at the end of every tenure of parliament, 5-year, 4-year, or even 7-year, the sluice gates are not opened to allow for unfettered contest. It doesn't exist anywhere. The parliamentary parties are given the responsibility to assess the performance of the members of parliament, and for those of them who operate optimally and bring value to bear on the functions of parliament and indeed of parliamentarians, the assessment will bear them out that the recommendation to the parties should be that they should be continued in office. Today, as we speak, over 50% of the current membership of parliament are new members. How do you grow parliament that way? You weaken parliament before the executive. And the executive then can have their way, because parliament doesn't have the wherewithal to be able to stand up to the executive. We have a parliamentary service board. Unfortunately, the minority leader and I added them. For whatever reason, the parliamentary service board, established by Article 124, has no bearing on members of parliament. It relates only to the parliamentary service, that's the staff, not the members of parliament. However that was done, nobody knows. It's one area that we have to look at again. And then the imperatives of Article 108, in the considered opinion of many, seek to forbid Parliament in the exercise of arguably its prime function, legislation. Parliament since 1997 has been endeavoring to find its way around it. It all started with Right Honorable Peter Alajete. His efforts did not yield much, since not too long after the exercise that he started, presidential and general elections came to be held, and his own party did not repeat him as the speaker. The chairman for this occasion, Speaker Professor Aaron Mike Oquaye, was the one who opened the vista by his own bold statement and subsequently allowing the consideration and passage of a couple of some amendment bills. The Speaker of the 8th Parliament is proving to be much more adventurous by allowing the presentation of fully fledged bills by members of Parliament in their private capacities and not on behalf of the President. Article 108, however, provides, and I quote, "Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, A, proceed upon a bill including amendment to the bill that, in the opinion of the person presiding, makes provision for any of the following: imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. And 2, the payment, issue, or withdrawal from the consolidated fund or any other public funds of Ghana of any monies not charged on the consolidated fund, or any increase in the amount of that payment, issue, or withdrawal, or proceed upon a motion, so and so." I think it's just replicas. Now, the question then to ask is, because of this avalanche of private bills, and some people are even providing amendments to the Constitution, and they are allowed by the current speaker with no malice to him. But the question is, given the avalanche of substantive private members' bills and the substantive motions in relation to the bills that have been introduced in Parliament, the questions that arise are, does the current speaker not have any opinion on these substantive bills? 2, or is it the case that the speaker opines that these bills shall not impose any charge on the consolidated fund or other public funds of Ghana? And if not, how are the bills after passage by Parliament going to be funded or be implemented? What is going to be the effects of these bills if Parliament passes them on the budget that has already been passed? Is Parliament, in the face of the imperatives of Article 108, deliberately setting itself on a collision course with the executive? And I think that even though Parliament must be liberated to exercise its legislative powers, there should be a policy regulating how it should be done. It shouldn't be a free-for-all enterprise. Notwithstanding the express provision of 108, the legislative responsibility of Parliament must be discharged, as I've said. Because the Constitution in Article 103.3 provides, committees of Parliament shall be charged with such functions, including the investigation and inquiry into activities and administration of ministries and departments as Parliament may determine. And such investigation and inquiries may extend to proposals for legislation. So indeed, Parliament is provided with that responsibility. How to exercise the responsibility is the issue that I'm raising. Now, immunity from service of process and arrest. Lately, some wranglings are dominating. Some members of Parliament have had encounters with the law enforcement agencies. Previous speakers have had a way about it. Lately, some wranglings are dominating the airways regarding witch hunting. In the face of Article 117, which provides civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker, a member of, or the clerk to Parliament whilst on his way to attending at or returning from proceedings of Parliament. What should be the appropriate defined path for MPs who breach the law? We must sort this one out in a better way to prevent what others may refer to as unwarranted damparic intrusions. The Constitution must be amended to punish wrong, whilst at the same time protecting the dignity and immunity of lawmakers. The financial autonomy of Parliament is something that we should be attending to, because the Constitution grants financial autonomy to the judiciary and the Auditor General, but not to the other arm of government, which is Parliament. Of course, if there should be an unguarded or unguided financial autonomy to Parliament, it becomes difficult, because whereas the judiciary have financial autonomy, it is for Parliament to oversee the activities. The Auditor General will oversee the activities. If it's down to Parliament, what happens to Parliament? Who watches the watchman? But we must still have a way about it. Otherwise, and I guess while talking about financial autonomy, the Electoral Commission is one constitutional body that must also have financial autonomy. Because you can have a very capricious president who may decide to stifle the conduct of activities and business by the Electoral Commission, and they may not be able to deliver. So we must look at this. And gratuities to Article 71 office holders. Article 71 provides for the President to determine the salaries and allowance payable and the facilities and privileges available to officers listed under Article 71, whilst Parliament makes the determination in respect of the President, Vice President, Chairman, and other members of the Council of State, Ministers of State and Deputy Ministers upon the recommendations of the committee that is established by the President. Those amounts are gratuities, not ex gratia. Gratuity is a sum of money given for a good or long service. Ex gratia are amounts that are given for a favor. What we do are not favors. We earn them. It's gratuity and not ex gratia. There's a world of difference. All presidents have established these Article 71 office holders and monument committees. The outcomes have always caused national uproar. Does the establishment have to be ritualistic? Or is it the case that one president can establish, say, and will build in triggers to affect succeeding administrations? The time has come for us to look at it again. The Supreme Court, the highest court of the land, comprises the Chief Justice and no less than 9 other justices of the Supreme Court. The upper limit is not set. We have seen instances where numbers have shot up to 14, 15. I guess the time has come to prevent any absurdities. let us set an upper limit in the Constitution, say the Chief Justice and not more than 12 or 14 others, and that would avoid even numbers and split decisions. For the qualification criteria of justices of the Supreme Court, the apex court of the land, the Constitution provides under Article 128(4), a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. Just that. Just that. Undoubtedly, in my view, the bar is too low. Check out the qualification and eligibility criteria for parliamentarians and other public office holders, such as the EC, NCC, SHRAC, Public Service Commission, and so on. The bar is much higher there. Yet those officers are likened to the justices of the Court of Appeal in their conditions of service. Yet the qualification and eligibility criteria is much, much higher than the justice of the Supreme Court. Article 1284 has to be amended. To whom much is given, much indeed is expected. And need I say that Article 126 of the Constitution provides for the composition and mode of exercise of the power of the judiciary. Article 126 states the judiciary of Ghana shall, that is, it must consist of: 1, the superior courts of judicature comprising the Supreme Court, the Court of Appeal, the High Court, the regional tribunals. Kofi, where are the regional tribunals? You put it there. The regional tribunals are still a composite part of our superior courts, but I thought the tribunal system, peoples or citizens, died with the revolution. Their ghosts still exist in the Constitution. Indeed, more ominously, the Court of Appeal is allowed to hear appeals from the regional tribunals, however constituted. Article 1311. Article 142 establishes and composes the regional tribunals, and their jurisdiction is defined under Article 143. We simply need to uproot the regional tribunals, root, stem, and branch from the judicial system. That means that the chapter on the judiciary has to be amended. Now, the Auditor General. The Auditor General is a tool for Parliament everywhere in the world in the performance of Parliament's financial oversight responsibilities. It is the reason why the Constitution provides for the Auditor General to submit his audited report to Parliament within 6 months after the immediately preceding financial year, Article 187(5). It is strange, therefore, that in the Constitution of Ghana, the Parliament of Ghana, which the Auditor General works to, cannot request the Auditor General to audit in the public interest the accounts of any public office or organization, but strangely, the President, the Executive, that Parliament provides oversight for, could do that. That power is granted to the President via Article 1877 and 1878. That indeed is an inversion, and it must be corrected in any constitutional review. The works of the Auditor General is not completed until they submit their report to Parliament, which through its Public Accounts Committee begins to interrogate the findings contained in the report. Therefore, the situation where Auditors General, their reports before they are submitted to Parliament, gets leaked to the press for people who are cited to be torn into shreds. It's most unfortunate and very unprofessional. Professor Chair, tolerate me for just a few more minutes. Article 286 of the Constitution provides for certain categories of public office holders to submit to the Auditor General a written declaration of all properties or assets owned by or liabilities owed by the office holders, whether directly or indirectly. The purpose for declaring assets and liabilities is for taxation and also to ensure that the person has a clean bill of health and that assets do not ensue from money laundering or ill-gotten wealth. But not so in Ghana, where assets that are declared are kept under lock and key by the Auditor General. It explains the reason why a person boldly declares, oh, as a last count, I have the last count, he said he had 150 houses. Where are those houses located? What's the value of those properties individually and collectively? How much property rates has that person paid to the various district assemblies where the properties are situated? The Auditor General must have the capacity to go into this. And yet, you declare the assets and put it somewhere. And some people even say to us that people who occupy public places in the assets declaration form would fill his own anticipations. He will tell you that when he has one house, he said, I have 5 houses. And he worked towards acquiring 5 houses. Another person on television declared that he has much more gold bars than anybody in Ghana. The tax authorities elsewhere would have immediately descended on that person. Yet nothing happened. Is GRA sufficiently empowered? Because the Constitution provides that the minerals in their natural state, everything is vested in the president. You go and mine. The mining and minerals laws provide that once you get a mineral, gold, diamond, or whatever, the country has preemption. Whatever you get, you declare to the state for the state to purchase from you. That's the law. These galamseyers, they get everything. The state doesn't know anything about it, and then they smuggle them out. So when the law provides that it's vested in the state, what benefit is coming from the state? They degrade the land, take the money away, and the nation is the poorer. It's the reason why on the books here in Ghana, our gold exports in the region of about 2.2 million ounces. And yet you step out, and the fact of the matter is that it's in the region of about 7.5 million. Where are they going? How do we account for them? Who pays what tax and royalties? So, Mr. Chairman, I have my minority leader here. Sometimes when I am overly loquacious, he says I want to reduce him to a minority voice. So I'll soon end. But there are many other matters that we should concern ourselves with. The district assemblies. You know what? One of the good things that is providing insurance to us in this country is the decentralization that we are pursuing. In the other countries contiguous to our republic, I don't want to mention names, but central government is far removed from the rural communities. Here by our practice, we're standing governance to the doorsteps of the ruralized. And in my view, it's something very good that we have done. We must deepen it. And when, on occasions where we cannot transfer the District Assembly Common Funds to the district, it becomes a bit problematic. Because where there's poverty, these people would feed on poverty and poison the atmosphere for central government and take over. We don't want that to happen. Let's ensure that the proper things are done. We have the transitional provisions, almighty transitional provisions. We have started with it for so long a time. What do we do? I think the time for us as a nation has arrived. Let's look at that. And I believe we can go into it and then do what is right. Finally, the amendment procedure of the Constitution established for the entrenched provisions are both tortious and torturous, to say the least. Many of the provisions we have related to are entrenched provisions, and none of them shall require a referendum of yes or no, any one of them. With regard to the non-entrenched provisions, the amendment path is not serenaded by legato. It requires painstaking efforts, and the exercise could also suffer political twists and turns, as happened in the attempt to have district chief executives elected by universal adult suffrage. So, Professor Chairman, I believe I've not in any way exhausted the issues at stake, but what I've done is just to provide some meat for us to chew on. I must express my profound gratitude to you all for tolerating me for so long. As I said, there are many areas that I've not been able to touch because of lack of adequate time. I however want to believe that I provided some food for thought on the subject, the need for a constitutional review. Once again, I thank you very much, and I believe in the coming days and weeks, it should be possible for all of us to digest or to subtract from what ideas that I have shared. Mr. Chairman, I thank you very much.